Property 384. Ch11, Easements. A. What is an easement? Easements are interests in land. Unlike fee simple ownership, they are non-possessory. Rather, they allow the easement holder to use or control someone else's land. Suppose Anna owns Blackacre, and Brad owns Whiteacre, which borders Blackacre. Anna would like to cross Whiteacre to reach Blackacre. She could ask Brad for permission to cross, but even if he says yes, permission can be revoked. Brad might also convey Whiteacre to a less welcoming owner. Anna may therefore wish to acquire a property interest that gives her an irrevocable right to cross over Whiteacre. If Brad conveys her this interest, by sale or grant, Anna now owns an easement of access, which is a right to enter and cross through someone's land on the way to someplace else. Terminology. Easements come in multiple flavors. The first distinction is between affirmative and negative easements. An affirmative easement lets the owner do something on, or affecting, the land of another, known as the servient estate, or servient tenement. The right is the benefit of the easement, and the obligation on the servient estate is its burden. As noted above, a common affirmative easement is an easement of access, also known as an easement of way, which requires the owner of the servient estate to allow the easement holder to travel on the land to reach another location. In the example above, Anna has an affirmative easement to cross Whiteacre, the servient estate, to access Blackacre. 1. A negative easement prohibits the owner of the servient estate from engaging in some action on the land. For example, if Anna has a solar panel on her property, she might acquire a solar easement from Brad that would prohibit the Ch11, Easements 385. Construction of any structures on Whiteacre that might block the sun from Anna's panel on Blackacre. 2. Another distinction is between easements appurtenant and easements in gross. An easement appurtenant benefits another piece of land, the dominant estate. The owner of the dominant estate exercises the rights of the easement. If ownership of the dominant estate changes, the new owner exercises the powers of the easement, the prior owner retains no interest. So if Anna's easement to cross Whiteacre to reach Blackacre is an easement appurtenant, Blackacre is the dominant estate. If she conveys Blackacre to Charlie, Charlie becomes the owner of the easement. In an easement in gross, the easement benefits a specific person, who exercises the rights of the easement rights regardless of land ownership. If Anna's easement to cross Whiteacre to reach Blackacre is an easement in gross, she keeps her easement even if she conveys Blackacre. In general, the presumption is in favor of an easement appurtenant over an easement in gross. Why do you think that is? Easements are part of the larger law of servitudes, which include real covenants and equitable servitudes. A servitude is a legal device that creates a right or obligation that runs with the land. A right runs with the land when it is enjoyed not only by its initial owner but also by all successors to that owner's benefited property interest. A burden runs with the land when it binds not only its initial obliger but also all successors to that obliger's burdened property interest. A servitude can be, among other things, an easement, profit, or covenant. These interests overlap, and the restatement, 3rd, of Property, Servitudes, 2000, seeks to unify them. 3. As a matter of history, however, easement law developed as a distinct set of doctrines, and this chapter gives them separate treatment. 4. Property 386. B. Creating easements. 1. Express easements. Because easements are interests in land, express easements are subject to the statute of Frauds. Failures to comply with the statute may still be enforced in cases of reasonable detrimental reliance. See, example restatement, 3rd, of property, servitudes, 2.9. Third parties. Easements are often created as part of the transfer of land, example selling a property, but retaining the right to use its parking lot. Traditionally, grantors could reserve an easement in the conveyed land for themselves, but could not create an easement for the benefit of a third party. This rule led to extra transactions. Where the traditional rule applied, if A wanted to convey to B while creating an easement for C, A could convey to C, who would then convey to B, while reserving an easement. The modern trend discards this restriction. See, example Minton v. Long, 19s.w.3d 231. 238, Tennessee CT App 1999. The California Supreme Court explained. The rule derives from the common law notions of reservations from a grant, and was based on feudal considerations. A reservation allows a grantor's whole interest in the property to pass to the grantee, but reviests a newly created interest in the grantor, while a reservation could theoretically vest an interest in a third party. The early common law courts vigorously rejected this possibility, apparently because they mistrusted and wished to limit conveyance by deed as a substitute for livery by season. Insofar as this mistrust was the foundation of the rule, it is clearly an inapposite feudal shackle today. Consequently, several commentators have attacked the rule as groundless and have called for its abolition. California early adhered to this common law rule. In considering our continued adherence to it, we must realize that our courts no longer feel constricted by feudal forms of conveyancing. Rather, our primary objective in construing a conveyance is to try to give effect to the intent of the grantor. In general, therefore, grants are to be interested in the same way as other contracts and not. You should, however, be aware of the importance of thoroughly investigating the applicable law in your jurisdiction. If you ever encounter servitudes in practice, Ch11, Easements 387. According to rigid feudal standards, the common law rule conflicts with the modern approach to construing deeds because it can frustrate the grantor's intent. Moreover, it produces an inequitable result because the original grantee has presumably paid a reduced price for title to the encumbered property. Willard v. First Church of Christ, Scientist, 7 calories 3D 473, 476-77, 1972, citations omitted. The modern restatement likewise dispenses with the traditional approach, allowing the direct creation of easements on behalf of third parties. Restatement 2.6. Some jurisdictions nonetheless retain the bar, citing reliance interests and the prospect that such easements create instability in title records. Estate of Thompson v. Wade, 509. N.E.2d 309, 310, NY 1987, the overriding considerations of the public policy favoring certainty in title to real property, both to protect bona fide purchasers and to avoid conflicts of ownership, which may engender needless litigation, persuade us to decline to depart from our settled rule. Internal citation and quotation omitted. There is an argument that the extra transactions required by the traditional rule promote better title indexing. The restatement observes, to avoid the prohibition, 2 conveyances must be used. The first conveys the easement to the intended beneficiary, the second conveys the servient estate to the intended transferee. The only virtue of the rule is that it tends to ensure that a recorded easement will be properly indexed in the land record system, but there are so many exceptions to the rule, where it is still in force, that it does not fill that function very well. Restatement, 3rd, of property, servitudes, 2.6 cmt. A. 2000. In light of Hardig v. Stratman. From our chapter on recording acts, are you persuaded that the benefits of a separate transaction for recording purposes outweigh the costs? 2. Implied easements. Easements may come into being without explicit agreements. They may arise from equitable enforcement of implied agreements or references to maps or boundary references in conveyances. Restatement, 3rd, of property, servitudes, 2.13. In this section, we focus on two forms of implied easements, an easement implied by existing use, and an easement by necessity. Both such easements commonly arise as a byproduct of land transactions. Property 388. A. Easement implied by existing use. An easement implied by existing use may arise when a parcel of land is divided and amenities once enjoyed by the whole parcel are now split up, such that in order to enjoy the amenity, a utility line, or a driveway, for example, one of the divided lots requires access to the other. Imagine, for example, a home connected to a city sewer line via a privately owned drain pipe, on a parcel that is later divided by carving out a portion of the lot between the original house and the sewer line connection. In such a situation, courts will frequently find an easement implied by prior existing use, allowing the owner of the house to continue using the drain pipe even though it is now under someone else's land. See, example Van Sant v. Royster, 83p.2d 698, Kansas 1938. There are, however, some limits to the circumstances that will justify the implication of such an easement. The easement implied from a pre-existing use is also characterized as a quasi-easement. Such an easement arises where, during the unity of title, an apparently permanent and obvious servitude is imposed on one part of an estate in favor of another part. The servitude must be in use at the time of severance and necessary for the reasonable enjoyment of the severed part. A grant of a right to continue such use arises by implication of law. An implied easement from a pre-existing use is established by proof of three elements. 1. Common ownership of the claimed dominant and servient parcels and a subsequent conveyance or transfer separating that ownership. 2. Before severance, the common owner used part of the united parcel for the benefit of another part, and this use was apparent and obvious, continuous and permanent. And 3. The claimed easement is necessary and beneficial to the enjoyment of the parcel, conveyed or retained by the grantor or transferor. Ch11, Easements 389. Dudley v. Neteller, 924 N.E.2d 1023, 1027-28, ILAP 2009, internal citations and quotations omitted. The following notes consider each of these elements. Notes and questions. 1. Common ownership. Are easements implied by prior existing use fair to owners of subdivided land? Why shouldn't we require purchasers of subdivided lots to get it in writing, that is, to bargain for easements to obvious and necessary amenities when accepting a parcel carved out from a larger plot of land? For that matter, why don't we require the original owner to bargain for the right to continue to use land that they are purporting to sell? Who do we think is in a better position to identify the need for such an easement, the prior owner of the undivided parcel, or the purchaser of the carved out portion of that parcel? Should the answer matter in determining whether to imply an easement or not? The common law did draw distinctions between implied reservation of an easement, to the owner of the original undivided lot, and implied grant of an easement, to the first purchaser of the separated parcel. The latter required a lesser showing of necessity than the former, which would only be recognized upon a showing of strict necessity. The theory was that the deed that first severed the parcels from one another should be construed against its grantor, who was in a better position to know of the need for an easement to property she already owned, and to write such an easement into the deed she was delivering. Indeed, a minority of jurisdictions still follow this rule. The modern restatement, in contrast, makes no distinction as to whether the easement is sought by the grantor or the grantee, providing simply that the use will continue if the parties had reasonable grounds to so expect. Factors tending to show that expectation are that, 1. The prior use was not merely temporary or casual, and, 2. Continuance of the prior use was reasonably necessary to enjoyment of the parcel, estate, or interest previously benefited by the use. And, 3. Existence of the prior use was apparent or known to the parties, or, 4. The prior use was for underground utilities serving either parcel. Restatement. Third, of property, servitudes, 2.12, 2000. The commentary allows for the possibility that the balance of hardships and grantor knowledge might justify a property 390. Courts refusing to imply a servitude in favor of the grantor when it would have for the grantee. IDCMT. A. But the general approach is to accept and accommodate the fact that grantors do not always protect themselves as well as they perhaps should. ID. Although grantors might be expected to know that they should expressly reserve any use rights they intend to retain after severance, experience has shown that too often they do not. 2. Reasonable necessity. Reasonable necessity is something less than absolute necessity. See, example renderer v. Kevin, 412 N.E.2d 1015, 1026, ILAP 1980. It is well established that one who claims an easement by implication need not show absolute necessity in order to prevail. It is sufficient that such an easement be reasonable, highly convenient, and beneficial to the dominant estate. Internal quotation and citation omitted. Does this leave courts with too much discretion to impose easements? A minority of jurisdictions make a formal distinction between implied easements in favor of grantees and grantors, requiring strict necessity in the case of the latter. Restatement 2.12. But see Tortoise Island Communities Incorporated v. Moorings Association, Inc., 489 So. 2D 22, 22. FLA 1986, concluding that an absolute necessity is required in all cases. 3. What is apparent? Should home purchasers be expected to investigate the state of utility lines upon making a purchase? The restatement, third, of property servitudes, reports that most cases to consider the question imply the easement when underground utilities are at issue. 2.12, reporters note, such easements will be implied without regard to their visibility or the parties' knowledge of their existence if the utilities serve either parcel. Are such uses plausibly apparent? Or is this simply a case of the law implying terms that the parties likely would have bargained for had they thought to consider the matter? B. Easements by necessity. An easement by necessity, or sometimes way by necessity, arises when land becomes landlocked or incapable of reasonable use absent an easement. For example, if A owns a rectangular parcel bordered on the north, east, and west by privately owned land and on the south by a public street, and conveys to B a strip of her land on the northern boundary, B will acquire an easement by necessity across the southern portion. of the parcel retained by a Ch11, Easements 391. Thomas v. Primus. 84A.3 D916, Con App 2014. Mihalakos, J. The plaintiffs, William Thomas, Craig B. Thomas and Andrea Thomas Jabs, appeal from the trial court's declaratory judgment granting an easement by necessity and implication in favor of the defendant, Bruno Primus. On appeal, the plaintiffs claim that the court erred in finding an easement by necessity. 1. The plaintiffs also claim that the defendant's claim for an easement should have been barred by the defense of laches. We affirm the judgment of the trial court. The following facts, as found by the court, are relevant to this appeal. The plaintiffs own property located at 460 Camp Street in Plainville. The defendant owns 1¼ acres of undeveloped land abutting the eastern boundary of the plaintiffs' property. The dispute at issue here concerns the northernmost portion of the plaintiffs' property, a 25 feet wide by 300 feet long strip of land known as the Passway, which stretches from the public road on the western boundary of the plaintiff's property to the defendant's property to the east. Both the plaintiff's and the defendant's properties originally were part of a single lot, owned by Martha Thomas, the grandmother of the plaintiffs. In 1959, Martha Thomas, property 392, conveyed the 1¼ acres of landlocked property, currently owned by the defendant, to Arthur Primus, the defendant's brother. At the conveyance, which the defendant attended, Martha Thomas and Arthur Primus agreed that access to the landlocked property would be through the passway, which until that time had been used by Martha Thomas to access the eastern portions of her property. In 1969, the defendant took possession of the land. In 2002, the plaintiffs took possession of the western portion of Martha Thomas's property, including the passway. In 2008, the plaintiffs decided to sell their property. When the defendant learned of their intention, he sent a letter to the plaintiffs asserting his right to use the passway to access his land. In 2009, the plaintiffs signed a contract to sell their property, but the prospective purchasers cancelled the contract when they learned of the defendant's claimed right to use the passway. The plaintiffs then brought the action to quiet title. That is the subject of this appeal, seeking, among other things, a declaratory judgment that the defendant had no legal interest in the property. The defendant brought a counterclaim asking the court to establish his right to use the passway uninterrupted by the plaintiffs. In response to the defendant's counterclaim, the plaintiffs asserted the special defense of laches. A trial was held on June 5 and 6, 2012. On August 31, 2012, the court issued its decision, finding in favor of the defendant on the plaintiff's complaint and on his counterclaim, and concluding that the defendant had an easement by necessity and an easement by implication over the passway. Specifically, the court found an easement by necessity was created when Martha Thomas conveyed a landlocked parcel to Arthur Primus, as it was absolutely necessary in order to access the property. Ch11, Easements 393. Convey land to the other, in such manner that the grantee could derive no benefit from the conveyance. Collins v. Prentice, 15 Con 39, 44, 1842. An easement by necessity is imposed where a conveyance by the grantor leaves the grantee with a parcel inaccessible save over the lands of the grantor. Hollywile Association, Inc. v. Hollister, 164. Con 389, 398, 324A.2 D 247, 1973. The party seeking an easement by necessity has the burden of showing that the easement is reasonably necessary for the use and enjoyment of the party's property. A. First, the plaintiffs claim that an easement by necessity does not exist because the defendant's predecessor in title had the right to buy reasonable alternative access to the street. We disagree. In considering whether an easement by necessity exists, the law may be satisfied with less than the absolute need of the party claiming the right-of-way. The necessity need only be a reasonable one. Holliwell Association, Inc. v. Hollister, Supra, 164 Con at 399, 324. A.2d 247. In this case, the plaintiffs presented evidence at trial that, at the time he purchased the property from Martha Thomas in 1959, Arthur Primus maintained bonds for deed that allowed him to purchase access to Camp Street through a different piece of property for $900. Although he did not exercise this right, the plaintiffs contend that the fact that Arthur Primus held this option establishes that the defendant's use of the passway is not reasonably necessary. The plaintiffs correctly note that the ability of a party to create alternative access through his or her own property at a reasonable cost can preclude the finding of reasonable necessity required to establish an easement by necessity. Nonetheless, we are aware of nothing in our case law that suggests that a party is required to purchase additional property in order to create alternative access, even at a reasonable price. 2. The plaintiff's sole authority in support of their position, Griffith v. Ide, 573 N.W.2d 829, N.D.1998, is distinguishable from the case before us. In that case, the North Dakota Supreme Court upheld a trial court's ruling that a party seeking an easement by necessity had not met his burden of establishing reasonable necessity. Because potential alternate access existed, including the possibility of purchasing an easement over another abutting property, and the party had not provided evidence that he had pursued these options and found them. Property 394. Furthermore, easements by necessity need not be created at the time of conveyance. See D'Addario v. Truskowski, 57 Con App. 236, 247, 749 A.2 D38, 2000, recognizing easement by necessity created by state taking and natural disaster. Even if we were to assume, arguendo, that Arthur Primus bonds for deed made use of the passway unnecessary at the time he owned the property, those bonds for deed expired in 1962. Several years before the defendant owned the property, and provide no reasonable alternative access today. Thus, we see no reason to disturb the court's finding that use of the passway is currently necessary for the use and enjoyment of the defendant's property. C. Finally, the plaintiffs argue that an easement by necessity does not exist because Martha Thomas and Arthur Primus did not intend for the easement to exist. We disagree. The seminal case in the state on easements by necessity recognized that the law will not presume that it was the intention of the parties that one should convey land to the other, in such manner that the grantee could derive no benefit from the conveyance. The law, under such circumstances, will give effect to the grant according to the presumed intent of the parties. Collins v. Prentice, Supra, 15 Con at 44, 15 Con 39. This rationale does not, as the plaintiffs suggest, establish intent as an element of an easement by necessity. Instead, the presumption as to the intent of the parties is a fiction of law, and merely disguises the public policy that no land should be left inaccessible or incapable of being put to profitable use. Citation omitted. Holliwell Association, Inc. v. Hollister, Supra, 164 Con at 400, 324 A.2 D 247. Thus, absent an explicit agreement by the grantor and grantee that an easement does not exist, a court need not consider intent in establishing an easement by necessity. See O'Brien v. Coburn, 46 Con App. 620, 633, 700 A.2 D 81, holding that the intention of the parties was irrelevant in case establishing easement by necessity, cert. Denied, 243 Con. 938, 702 A.2 D 644, 1997. In this case, the court found that the defendant's property was landlocked and that access over the passway was reasonably necessary for the use and enjoyment of the unavailing. In this case, there is no evidence in the record that the defendant had the opportunity to purchase alternate access. Ch11, Easements 395. Defendant's property. Therefore, the court found an easement by necessity to exist over the passway. This conclusion was supported by the record and there is no legal deficiency in the court's analysis. Notes. 1. As Thomas indicates, there are two traditional rationales for easements by necessity. The first considers it an implied term of a conveyance, assuming that the parties would not intend for land to be conveyed without a means for access. The second simply treats the issue as one of public policy favoring land use. See Restatement, 3rd, of Property, Servitudes, 2.15 CMT. A. 2000. 2. Thomas's implication to the contrary aside, the traditional view is that the necessity giving rise to an easement by necessity must exist at the time the property is severed. Restatement, 3rd, of Property, Servitudes, 2.15, 2000. Servitudes by necessity arise only on severance of rights held in a unity of ownership. Roy v. Euro-Holland Vastgoed, BV, 404 So. 2D 410, 412, FLA. DISTCT App 1981, in order for the owner of a dominant tenement to be entitled to a way of necessity over the servient tenement, both properties must at one time have been owned by the same party. In addition, the common source of title must have created the situation causing the dominant tenement to become landlocked. A further requirement is that at the time the common source of title created the problem, the servient tenement must have had access to a public road. 3. Easements by necessity are typically about access, but other kinds of uses may be necessary to the reasonable enjoyment of property. For example, suppose A conveys mineral rights to Blackacre to A would have both an easement of access to Blackacre and the right to engage in the mining necessary to reach the minerals. Likewise, an express easement of way may require rights to maintain and improve the easement. Access for utilities may also give rise to an easement by necessity, creating litigation over which utilities are necessary. When questioned by defendants as to why he could not use a cellular phone on his property, plaintiff testified he ran a home business and a cellular phone was not adequate to handle his business needs. 4. Property 396. Example, a computer cannot access the internet over a cellular phone. Plaintiff also testified solar power and gas generators were unable to produce enough electricity to make his home habitable. Smith v. Haysinger, 745 N.E.2 D 666, 672, IL App 2001, affirming finding of necessity of easement for underground utilities. Courts often describe the degree of necessity required to find an easement by necessity as being strict. See Example Ashby Meekling, 229 p.3 d 1210, 1214. Mont 2010, two essential elements of an easement by necessity are unity of ownership and strict necessity. It is certainly higher than that needed for an easement implied by existing use. That said, considerable precedent indicates that the necessity need not be absolute. See, example KLV. Wanamaker, 121 NJ. Super. 142, 148, 296 A.2 D 329, 333, CHDIV 1972, although some courts have held that access to a piece of property by navigable waters negates the necessity required for a way of necessity, the trend since the 1920s has been toward a more liberal attitude in allowing easements despite access by water, reflecting a recognition that most people today think in terms of driving rather than rowing to work or home. 4. Several states provide owners of landlocked property a statutory right to obtain access through neighboring land by means of a private condemnation action. Some courts have held that the availability of private condemnation actions negate the necessity prong of a common law easement by necessity claim. See example Ferguson Ranch Incorporated v. Murray, 811 p.2 d 287, 290, Wyoming 1991, a civil action for a common law way of necessity is not available because of the existence of WS 24, 9, 101. Private condemnation actions may also extend to contexts beyond those covered by the common law easement by necessity. See example Cal. Civ. Code 1001, Utilities. 3. Prescriptive easements. Easements may also arise from prescription. An easement by prescription is acquired in a manner similar to adverse possession, as it is a non-permissive use that ultimately ripens into a property interest. Recall the 5 elements of adverse possession, entry and possession, that is, 1. Actual, 2. Exclusive, 3. Hostile or under claim of right, 4. Ch11, Easements 397. Open and notorious, and 5. Continuous for the statutory limitations period, which, if any, of these elements might have to be modified where the right being acquired is not a right of possession, but a right of use. Felgenhauer v. Sony. 17 Cal.RPTR.3 D 135, Cal App 2004. Gilbert, P.J. Here we hold that to establish a claim of right to a prescriptive easement, the claimant need not believe he or she is legally entitled to use of the easement. Jerry and Kim. Felgenhauer brought this action to quiet title to prescriptive easements over neighboring property owned by Ken and Jennifer Sony. A jury made special findings that established a prescriptive easement for deliveries. We affirm. Facts. In November of 1971, the Felgenhauers purchased a parcel of property consisting of the front portion of 2 contiguous lots on Spring Street in Paso Robles. The parcel is improved with a restaurant that faces Spring Street. The back portion of the lots is a parking lot that was owned by a bank. The parking lot is between a public alley and the back of the Felgenhauers restaurant. From the time the Felgenhauers opened their restaurant in 1974, deliveries were made through the alley by crossing over the parking lot to the restaurant's back door. The Felgenhauers never asked permission of the bank to have deliveries made over its parking lot. The Felgenhauers operated the restaurant until the spring of 1978. Thereafter, until 1982, the Felgenhauers leased their property to various businesses.